Silence now. HOA mandates it.
My baby got burned because of you.
Christine was pouring boiling water onto Mia's face. My 8-month-old daughter was screaming in her bassinet, the bassinet where she slept on the blanket her dead mother had knitted. And Judge Patricia Morrison was watching it happen live on Zoom, her face frozen in horror, already reaching for her phone to dial 911. Emergency noise abatement. HOA Enforcement Authority permits necessary remediation of ongoing violations. I'm a family law attorney. 11 years specializing in child welfare and HOA disputes. The moment Christine Mercer claimed HOA authority to justify assaulting my infant daughter, I knew I needed to verify that authority existed, because if it didn't, everything she just did was fraud. If you've ever watched someone attack the only family you have left while claiming legal authority, you'll understand. So, hit subscribe now. I'm Nathan Cole. I've handled 30 cases where HOAs exceeded their legal boundaries. I know corporate charter requirements. I know when organizations lack proper standing. And as I lunged across my home office, screaming, grabbing Mia from the bassinet while her face blistered, while Judge Morrison yelled through my laptop that emergency services were coming, one thought cut through the panic. I need to check if Riverside Commons HOA is properly incorporated, because Christine just committed child abuse under claim of authority that might not legally exist. But I need you to understand what that blanket meant, why Mia matters beyond just being my daughter. My wife Jessica died 5 months ago. Postpartum complications, blood clots that caused cardiac arrest when Mia was 3 months old. One moment, Jessica was holding our baby. The next, paramedics were performing CPR in our living room, while I held a crying infant who'd just lost her mother. The baby blanket in Mia's bassinet, pink and white, hand-knitted during pregnancy, was Jessica's last gift to our daughter. She'd spent hours creating it. Each stitch a promise. Each row a hope for the future. Jessica knitted that blanket while her body was preparing to betray her, while blood clots were forming that would kill her 3 months after giving birth. That blanket was all Mia had of her mother. The physical proof that Jessica had loved her, had planned for her, had dreamed of wrapping her baby in warmth. Now it was soaked with Mia's blood, stained red from second-degree burns the HOA president had just inflicted, because Mia had colic, cried at night. Normal infant behavior that Christine Mercer, former pharmaceutical compliance officer who'd never had children and seemed to hate families who did, had classified as noise violation requiring immediate remediation. We'd been in the middle of a virtual HOA hearing, Judge Morrison mediating from her chambers via Zoom. Christine had demanded to attend from my house for noise level verification. I'd thought she'd observe. Instead, she went to my kitchen, boiled water, carried the pot, into my home office where Mia was crying, and poured it directly onto my daughter's face while claiming HOA Emergency Enforcement Authority. The board chair was still standing there, pot in hand, when I grabbed Mia. My daughter's screams were different now, not crying, agony. Her face was blistering, turning red, the skin already starting to peel. What did you do? What did you... The noise violation was unacceptable. I conducted necessary enforcement. Christine's voice was calm, clinical. HOA charter grants emergency remediation authority when violations threaten community quiet enjoyment. Judge Morrison's voice came through the laptop speakers. Mr. Cole, emergency services are on the way. I've recorded everything. Ms. Mercer, you are to remain exactly where you are. What I just witnessed was lawful HOA enforcement, the former compliance officer interrupted. The board voted to grant me emergency powers to address ongoing. You poured boiling water on an infant. The Judge's voice was steel. "I watched you do it during an official proceeding while claiming organizational authority." That's when it clicked for me. Corporate authority. Christine kept saying HOA authority and charter grants and board voted. Legal terms that required legal standing. Which meant I needed to verify that Riverside Commons HOA actually had the corporate authority Christine was claiming. Because if the HOA wasn't properly incorporated, if it lacked legal standing, then every word Christine just said, every justification for assaulting my daughter, was fraud. Sirens approaching, Mia screaming in my arms, Jessica's blanket ruined, and the woman who'd burned my baby's face was still claiming she'd acted under legitimate authority. I was going to find out if that authority existed, and if it didn't, I was going to make sure Christine Mercer lost everything. The paramedics arrived within 4 minutes. Detective Sarah Chen was right behind them. Judge Morrison had apparently called not just 911, but directly requested a detective for what she'd witnessed. Mia's screaming hadn't stopped. The lead paramedic examined her face with careful hands and an expression that told me everything I needed to know before he spoke. Second and third degree burns. We need to transport immediately to Children's Hospital Burn Unit. Sir, are you her father? Yes. Nathan Cole. She's 8 months old. My voice sounded distant, hollow. Her mother died 5 months ago. Mia's all I have left. We're going to take excellent care of her, but Mr. Cole, these burns, they're going to require surgery, possibly skin grafts. I need you to prepare for that. Christine Mercer was giving her statement to Detective Chen, still using that calm, clinical tone. The infant's excessive crying constituted ongoing noise violation. I attempted verbal warnings. When non-compliance persisted, I utilized emergency remediation protocols granted under HOA charter authority. You poured boiling water on a baby, Detective Chen interrupted. That's child abuse, not HOA enforcement. The board voted to grant me emergency powers to address violations that threaten community standards. I acted within authorized scope. Ma'am, you're under arrest for child abuse and assault causing serious bodily injury. I watched them handcuff the former compliance officer, watched her face shift from confident to confused to indignant. I have legal authority. The HOA charter explicitly grants, you can explain that to the judge. Detective Chen looked at me. Mr. Cole, I'll need your statement, but first, go with your daughter. At Children's Hospital, Dr. Amanda Rodriguez met us in the emergency burn unit. She examined Mia's face while I held my daughter's hand, trying not to break down completely. Mr. Cole, your daughter has second-degree burns covering approximately 15% of her face. Third-degree burns on her left cheek and forehead. We're going to need to do emergency debridement, that's removal of damaged tissue, and likely skin grafts in the next few days. Will there be scars? Dr. Rodriguez's pause told me everything. Possibly. We'll do everything we can to minimize scarring, but with burns this severe, especially on an infant whose skin is still developing, she could be scarred for life. Yes. I looked at Mia, sedated now, her face covered in protective dressings. 8 months old, lost her mother at 3 months, and now this. While Dr. Rodriguez prepped Mia for emergency surgery, I stepped into the hallway and called my office. I need someone to pull Riverside Commons HOA's incorporation documents, every filing with the Colorado Secretary of State, every amendment, everything. My paralegal Marcus knew better than to ask why. I'll have it within the hour. Detective Chen found me in the surgical waiting room 3 hours later. Mr. Cole, we have Judge Morrison's statement. She witnessed the entire incident during your virtual hearing. We also have the Zoom recording. She'd activated recording when she started the hearing. Everything Christine Mercer did is on video. What's she claiming? That she had HOA authority, that the board granted her emergency enforcement powers, that your daughter's crying violated community noise ordinances, and she was conducting necessary remediation. Detective Chen sat beside me. Mr. Cole, I've been doing this job for 12 years. I've never seen someone claim organizational authority to justify assaulting a child, which is why I need to verify that the authority she's claiming actually exists. You think the HOA doesn't have the power she says it does? I think Christine Mercer poured boiling water on my daughter while repeatedly invoking HOA charter authority, board votes, and emergency powers. Those are specific legal terms. They require proper corporate standing. I pulled out my phone, opened my email. Marcus had sent the documents. And if Riverside Commons HOA lacks proper incorporation, then every word she said was fraud. I started reading through the incorporation filings. Articles of incorporation dated 2016. Looked official. Had all the right language about powers, authorities, enforcement mechanisms. Then I saw the stamp from the Colorado Secretary of State. Rejected. Deficiencies in filing. Resubmit with corrections. My blood went cold. What is it? Detective Chen asked. The HOA President's incorporation papers were rejected 8 years ago. I scrolled through the rest of the documents Marcus sent. And I don't see any successful refiling, no corrected submission, no approved incorporation certificate. What does that mean? It means Riverside Commons HOA might not legally exist, which means Christine Mercer had no authority to enforce anything, which means everything she just did, every fine she's ever imposed, every violation she's ever issued, every piece of authority she's claimed, has been fraud. The board chair had just burned my daughter's face under false claim of legal power that never existed, and I was going to prove it. David Park showed up at the hospital that evening. I recognized him from HOA meetings. Board treasurer, always sitting beside Christine taking notes. He stood in the doorway of the surgical waiting room, hands shoved deep in his pockets, pulled them out, shoved them back in. His shoulders were hunched like he was trying to make himself smaller. Mr. Cole, I'm David Park from the HOA board. His voice was barely audible. I heard about your daughter, about what Christine... He couldn't finish the sentence. You're the treasurer. Yes, Can we talk? Not here. My car? We went to the parking garage. David sat in his driver's seat, gripping the steering wheel even though the engine wasn't running. His knuckles were white. He kept looking in the rearview mirror like he expected someone to appear. I saw the news, the arrest, what she did to your baby. He released the steering wheel, wiped his hands on his pants like they were sweating. Mr. Cole, I am a CPA. I do financial audits. 2 years ago, I was going through the HOA's books, and I found something. He pulled out his phone, deleted something, put the phone away, took it back out. His hands were shaking. David, what did you find? The incorporation papers. I needed them for the audit, to verify the HOA's legal standing for tax purposes. That's when I saw it. He looked at me, then away, then back. The filing was rejected, 2016. Colorado Secretary of State sent a rejection letter, deficiencies in the documents. They said to correct and resubmit. But no one ever resubmitted. No, The HOA has been operating without legal corporate existence for 8 years, collecting fees, imposing fines, threatening liens, all without any legal authority to do so. My attorney brain was already calculating the implications. That's fraud, theft by deception, every fee collected, every fine imposed. I know what it is. David's jaw clenched. He gripped the steering wheel again. I'm a CPA, Mr. Cole. I know exactly what it is. I've been sitting on this for 2 years, knowing we've been collecting money from 180 families under false pretenses. Why didn't you report it? He looked at me with guilt and fear fighting for dominance in his expression. Because I have twin daughters. They're 2 years old. And when I told Christine about the incorporation failure, when I said we needed to correct it immediately, he trailed off, started the car, turned it off. She came to my house, watched my girls playing in the backyard, said it would be unfortunate if someone filed complaints about our swing set, said code enforcement gets very aggressive about safety violations involving young children. She threatened your daughters. Not directly, never directly. That's how the former compliance officer works. She talks about unfortunate situations and aggressive enforcement and young children at risk. But the message was clear. If I revealed the incorporation failure, she'd make my family's life hell. David's hands wouldn't stop moving, adjusting the mirror, touching the radio, gripping the wheel. I told myself it was just paperwork, just a technicality, that as long as the community was running fine, the incorporation status didn't really matter. I told myself my daughter's safety was more important than corporate compliance. But Christine kept enforcing rules, aggressively, especially against families with young children, like she had something against kids, noise violations for crying babies, playground restrictions, pool hour limitations. She issued $85 in fines to 7 families over the past 3 years, all families with infants or toddlers. Under authority the HOA didn't have. Yes, and I watched it happen. Watched families pay fines because they thought they had to. Watched the board chair threaten. People with liens that had no legal basis. Watched her use fake corporate authority to terrorize residents. He looked at me, broken. Then I saw the news tonight. Saw what she did to your daughter. Saw her on camera saying HOA authority and charter powers, and I can't anymore. I can't watch another family get hurt because I was too afraid to speak up. David, I need documentation, the rejected incorporation, financial records, proof that Christine knew about the failure and continued enforcing anyway. He pulled a folder from under his seat, handed it to me with trembling hands. Everything's in there. Rejection letter, emails where I warned her, financial records showing 8 years of fee collection, evidence of the fines she's imposed, all of it. Christine will retaliate. Let her try. She poured boiling water on a baby. I have 2 daughters. If I don't help stop her now, what does that make me? I opened the folder, found the Secretary of State rejection letter dated August 2016. Found David's email to Christine from 2023. We need to address the incorporation issue immediately. Operating without legal standing creates massive liability. Found Christine's response. The community doesn't need to know about administrative paperwork issues. Continue normal operations. The board chair had known for at least 2 years that the HOA lacked legal authority, and she'd continued collecting fees, imposing fines, and threatening residents anyway. Fraud, systematic, deliberate, with my daughter's burned face as the final, horrifying consequence. Detective Chen called me the next morning while I was sitting beside Mia's hospital bed. "Mr. Cole, we need you at the station. Christine Mercer is claiming her actions were legally justified. She's demanding we release her and charge you with interfering with HOA enforcement." "She's still claiming authority? Won't stop. Her attorney is here with copies of HOA bylaws, board resolutions, charter documents. They're arguing this is a civil HOA matter, not criminal assault." I looked at David Park's folder on the bedside table. At the rejection letter that proved everything Christine claimed was built on fraud. "I'll be there in 20 minutes. At the police station, Christine sat in the interrogation room with her attorney, Richard Morrison. The former compliance officer looked composed, confident, like she was conducting a business meeting instead of facing child abuse charges. Detective Chen played the Zoom recording, Christine pouring boiling water, Mia screaming, Judge Morrison calling 911. "As you can see," Richard said, "Ms. Mercer was conducting emergency enforcement under HOA authority." "She burned an 8-month-old baby's face," Detective Chen interrupted. "She utilized necessary remediation of a noise violation that had persisted despite warnings. The HOA charter grants emergency powers when violations threaten community standards." I spoke through the one-way glass intercom. "What? HOA charter?" Christine's head snapped toward the glass. She couldn't see me, but she knew my voice. "Mr. Cole is present as the victim's father," Detective Chen said. "He has questions about the corporate authority you're claiming." Riverside Commons is a properly incorporated homeowners association registered with Colorado. Richard pulled out documents. Articles of incorporation, bylaws, board resolutions granting emergency enforcement powers. "Those articles were rejected by the Secretary of State in 2016, I said. "Never corrected, never refiled, never approved." The confidence on Christine's face flickered, just for a second, then returned. "Administrative paperwork delays don't negate operational authority. They do when Colorado law requires proper incorporation for HOA enforcement power." I entered the interrogation room, placed David's folder on the table. "This is the rejection letter from the Colorado Secretary of State, dated August 14th, 2016. Your incorporation. Filing was rejected due to deficiencies. It says, correct errors and resubmit. Until approved filing is received and processed, this entity has no legal corporate existence." Richard grabbed the letter. "Read it." His face went pale. "There must be a corrected filing." "There isn't. I checked the Secretary of State database this morning. No successful incorporation filing exists for Riverside Commons HOA, which means for 8 years you've been operating without legal authority." The board chair's jaw tightened. "The community needs governance. The community needs a legally incorporated HOA, which you're not, which means every fine you've imposed, every violation you've issued, every enforcement action you've taken, including pouring boiling water on my daughter, was done without any legal authority whatsoever. We collected fees in good faith. You collected fees knowing the incorporation was rejected. This is David Park's email to you from 2 years ago. I placed it on the table. Your own treasurer warned you about the incorporation failure. You told him to continue normal operations and not tell the community about administrative paperwork issues. Christine stared at the email, at her own words confirming she'd known. That's privilege board communication. That's evidence of fraud. You knew Riverside Commons lacked legal standing. You continued collecting fees anyway. You continued imposing fines. You continued threatening residents with enforcement actions your organization had no legal power to take. I looked at Detective Chen. And when my daughter's crying became inconvenient, she used this fake authority to justify assault. Richard was reading through David's documentation. His expression went from pale to sick. Christine, we need to talk privately. I acted under HOA authority. You acted under claimed authority that didn't exist, I said, which makes it fraud, theft by deception, operating a fraudulent corporation, and assault under color of false authority. The community believed the HOA was legitimate because you never told them it wasn't. You've collected approximately $400,000 in fees over 8 years, imposed $85,000 in fines, threatened dozens of families with liens, all while knowing you had no legal standing to do any of it. The former compliance officer's composure was cracking. I was protecting property values. You were running a fraud, and my daughter's face is burned because you convinced yourself your fake authority was real. Detective Chen spoke carefully. Ms. Mercer, these documents suggest your HOA has been operating without legal incorporation for 8 years. Can you explain how you have enforcement authority without corporate existence? Christine looked at her attorney, at the rejection letter, at the email proving she'd known, at the systematic fraud David had documented. The board voted. A board with no legal standing can't grant authority it doesn't have, I said. You poured boiling water on my daughter claiming HOA emergency powers. Those powers don't exist. They never existed, and you knew it. Riverside Commons enforcer was finally understanding what she'd done. Not just the assault, the fraud, the 8 years of illegal operation, the $550,000 plus collected under false pretenses, and the child abuse charge that would send her to prison for a crime committed under authority that was fiction. I went to my law office after leaving the police station, needed to verify everything systematically, document every piece of the fraud David had exposed. Started with the Colorado Secretary of State's business database, public records available to anyone who knows where to look. Searched Riverside Commons Homeowners Association. Results: 1 filing, August 2016. Status: rejected. I pulled the complete record. Read every line. Articles of incorporation. Riverside Commons, HOA filed, August 14, 2016. Status: rejected. Deficiencies in documents. Reason: Article 3, Corporate Powers, contains language inconsistent with Colorado Revised Statutes. Title 7, Article 5, Board Authority, exceeds statutory limits for nonprofit corporations. Correct deficiencies and resubmit within 90 days. Rejection date: August 28, 2016. Corrected refiling, none on record. I searched for any subsequent filings, any amendments, any evidence that someone had corrected the errors and resubmitted. Nothing. In 8 years, no one had fixed the incorporation papers, which meant Riverside Commons HOA had never legally existed as a corporate entity. Under Colorado law, HOAs must be properly incorporated to have enforcement authority. Colo, Reverend Stat, Paraf 38, 33.3, 201. Without incorporation, an HOA is just a group of neighbors with no legal standing to impose fines, place liens, or enforce covenants in court. Every violation notice Christine had issued, legally meaningless. Every fine she'd collected, theft by deception. Every lien she'd threatened, fraud. Every claim of HOA authority she'd made, fiction. I pulled Riverside Commons financial records from David's folder. 8 years of fee collection. Monthly dues, $180 per household, 180 homes, $180 or 180 homes x 12 months, 8 years. However, $110,400, over $3 million collected by an organization with no legal authority to collect fees. Then the fines. David had documented $85,000 in noise violation fines imposed on families with young children over 3 years. But I needed the full picture. I called David. I need complete records, every fine imposed since 2016, every violation notice, every enforcement action the board chair took. I'll compile everything. Mr. Cole, when I saw those numbers during my audit, I knew it was wrong, but seeing it all together, it's systematic fraud, operating a fake corporation for profit. I spent the next 4 hours building the case, not just Christine's assault, the entire fraudulent operation. Corporate fraud. Evidence. Incorporation rejected, never corrected, verified through Secretary of State. Christine knew about rejection. David's 2023 email, her response. Continued operations despite lack of legal standing. Collected $3.1 million in fees without authority, imposed $150,000 in applause. In fines without legal basis. Threatened liens, HOA had no power to place. Claimed enforcement powers that didn't exist. Pattern of targeting families. David had detailed records. 7 families with young children, all targeted for noise violations between 2021 to 2024. Morrison family, $12,000 in fines, infant colic. Chen family, $8,500 in fines, twin toddlers. Rodriguez family, $15,000 in fines, baby crying at night. Kim family, $11,000 in fines, 3 children under 5. Patterson family, $14,000 in fines, newborn with reflux. Williams family, $13,500 in fines, autistic child, loud stimming. Anderson family, $11,000 in fines, baby with health issues. Total, $85,000 in fines imposed on families with young children. All under false claim of authority. Christine's assault, the culmination. 8 years of fake authority. Families paying illegal fines. The former compliance officer convincing herself her power was real, until she escalated to pouring boiling water on an 8-month-old baby's face, while claiming HOA emergency enforcement authority that had never existed. I drafted the legal analysis for the district attorney. Criminal charges recommended child abuse, existing charge, assault causing serious bodily injury, existing, operating fraudulent corporation, Kolos Rev Stat, Barriger of 18 to 5, it's 902. Theft by deception, collecting fees without authority. Criminal impersonation, claiming corporate powers fraudulently. Conspiracy to defraud, with knowledge of incorporation failure. Civil remedies, void all HOA actions taken without legal authority. Return all fees collected illegally, 3.1 mem plus. Return all fines imposed without standing, 150K plus. Void all liens threatened or placed class action on behalf of all. Residence damages for families targeted and families who paid under false pretenses. I looked at the incorporation rejection letter again. Read the Secretary of State's stamp. Rejected, no legal corporate existence. 8 years. The board chair had operated a fake HOA for 8 years, collected millions, terrorized families, convinced everyone, including herself, that her authority was real. Then she'd used that fake authority to justify assaulting my daughter. My phone rang. Detective Chen. Mr. Cole, the DA wants to meet. Your fraud evidence, it changes everything. Christine Mercer isn't just facing child abuse charges anymore. She's facing potential decades in prison for running a fraudulent corporation that collected millions from residents who thought they were paying legitimate HOA fees. When does he want to meet? Tomorrow, 9 a.m. Bring everything you have, because we're not just prosecuting an assault anymore. We're prosecuting 8 years of fraud that culminated in violence against an infant. I looked at my computer screen. At the incorporation rejection that proved Riverside Commons HOA had never legally existed. At the financial records showing systematic theft. At the evidence of families terrorized under false authority. The tyrant in heels had built an empire on legal fiction, had convinced 180 families to pay fees to an organization that didn't exist, had imposed fines no one legally owed, had threatened enforcement actions she had no power to take. And when my daughter cried, she'd use that fake authority to justify burning a baby's face. Now I was going to prove every bit of power she'd claimed was fraud, and make sure she lost her freedom for decades. I went back to the hospital that evening, carrying all the fraud evidence I'd compiled. Mia was in surgery, the skin graft procedure Dr. Rodriguez had warned about. Dr. Rodriguez found me in the surgical waiting room 4 hours later. Her expression told me everything before she spoke. "Mr. Cole, the surgery went well. We were able to graft healthy skin from her thigh to cover the worst of the burns on her face. But I need you to understand what we're dealing with. Scarring. Yes, Mia is 8 months old. Her facial skin is still developing. The burns were severe, 2nd degree across 15% of her face, 3rd degree on her left cheek and forehead. Even with the grafts, even with the best plastic surgery we can do, she's going to have visible scarring." Dr. Rodriguez pulled up images on her tablet. "We'll do everything possible to minimize it as she grows. Multiple reconstructive surgeries over the years. But, Mr. Cole, your daughter will carry these scars for the rest of her life." I looked at the post-surgical photos, at Mia's face covered in bandages, at the permanent damage the former compliance officer had inflicted in the name of noise abatement. How many surgeries? At least 3 more over the next 5 years, possibly more as she grows, and the scar tissue needs to be revised. We're talking about a childhood of medical procedures, years of plastic surgery, the psychological impact of growing up with visible facial scarring. Because Christine Mercer thought HOA authority justified pouring boiling water on a baby. Mr. Cole, in my 20 years as a pediatric burn specialist, I've never seen someone deliberately scald an infant over noise complaints. Dr. Rodriguez sat beside me. What that woman did, there's no medical justification, no child welfare justification. It was assault, pure and simple. When they let me see Mia in recovery, I sat beside her bed and looked at Jessica's baby blanket, still blood-stained, still carrying the evidence of what Christine had done. Jessica had knitted this blanket while pregnant, while her body was preparing to betray her with blood clots that would kill her 3 months after giving birth. Every stitch was a promise to our daughter. Every row was hope for Mia's future. Now that future included permanent facial scars, years of reconstructive surgery, growing up with visible reminders of the day an HOA president burned her face. I pulled out my phone, called the district attorney's office. "This is Nathan Cole. I'm the father in the Christine Mercer child abuse case. I have evidence that changes everything. Riverside Commons HOA was never legally incorporated. Every piece of authority Mercer claimed when she assaulted my daughter was fraud." The DA, Patricia Walsh, listened while I explained. The rejected incorporation, the 8 years of illegal operation, the $3.1 million in fees collected without authority, the systematic targeting of families with young children. "Mr. Cole, if what you're saying is accurate, if this HOA has been operating without legal standing for 8 years, we're looking at criminal enterprise charges, organized fraud, theft by deception on a massive scale." And my daughter's assault was the culmination, 8 years of fake authority convincing Mercer her power was real, until she escalated to violence against an infant. How soon can you get me this evidence? Tomorrow morning, 9 a.m. I have everything. Incorporation rejection, financial records, pattern of targeting families, documentation that Christine knew about the incorporation failure and continued operations anyway. After we hung up, I sat watching Mia sleep, 8 months old, lost her mother at 3 months, now permanently scarred because Riverside Commons enforcer had operated a fraudulent HOA for nearly a decade. Dr. Rodriguez had said Mia would need years of surgery, would carry these scars forever, would grow up answering questions about what happened to her face. And I was going to make sure everyone knew the answer. An HOA president who operated a fake corporation for 8 years assaulted her under false claim of authority she never had. This wasn't just about criminal charges anymore. This was about exposing the entire fraud, voiding every action Christine had taken, returning every dollar illegally collected, freeing 180 families from an organization that had no legal right to exist. My phone buzzed. Text from David Park. 7 families willing to testify about targeting. Total fines paid, $85,000. All have young children. All were threatened with liens that had no legal basis. We can prove systematic discrimination and fraud. I looked at Mia's bandaged face, at Jessica's blood-stained blanket, at the evidence of assault committed under fake authority. The board chair had convinced herself that operating without incorporation was just an administrative paperwork issue, had collected millions from families who thought they were paying legitimate fees, had terrorized parents of young children with violations and fines no one legally owed. Then she'd poured boiling water on my daughter's face and called it HOA enforcement. I was going to prove every bit of authority she'd claimed was fiction, was going to void 8 years of fraudulent operation, was going to make sure Christine Mercer spent decades in prison for assault and fraud. And I was going to make sure Mia grew up knowing that when someone uses fake authority to hurt you, there are legal weapons that destroy them completely. This changed everything. No longer just seeking justice for assault, seeking total exposure of the fraud, complete destruction of Christine's fake empire, criminal prosecution plus civil remedy that freed an entire community. The tyrant in heels was about to learn that building power on legal fiction means losing everything when that fiction is exposed. David Park called me the next morning. Mr. Cole, I need to give you everything, not just the documents I showed you, everything I've uncovered over 2 years of knowing about this fraud. We met at a coffee shop 20 miles from Riverside Commons, neutral territory where Christine's influence couldn't reach. David arrived carrying 3 file boxes and a laptop, set them on the table between us like he was unloading a physical burden that had been crushing him. I've been the treasurer for 5 years, CPA by training. I'm supposed to catch financial irregularities, supposed to protect the organization's fiscal integrity. His hands were steady now, resolved. Instead, I watched Christine Mercer run a fraudulent corporation for 2 years after I discovered it, and I said nothing because I was afraid for my daughters. David, no, let me finish, because I need to say this. He opened the first box. When I saw your baby on the news, saw her face bandaged, saw what the board chair did while claiming HOA authority, I realized my silence made me complicit. Those burns on Mia's face, I could have prevented them if I'd exposed the fraud 2 years ago. He pulled out financial ledgers, bank statements, tax filings. Riverside Commons has collected $3,147,600 in HOA fees since 2016. That's $180 monthly dues from 180 homes over 96 months. David's CPA precision was evident in every number. All collected without legal corporate authority. That's textbook theft by deception under Colorado law. Christine knew. She knew. He opened his laptop, pulled up email threads. This is from September 2016, 1 month after the incorporation rejection. Email from the community organizers to Christine. Secretary of State rejected our filing. Need to correct errors and resubmit. Christine's response. We'll address the paperwork issue later. Begin collecting dues as planned. She decided to operate without legal standing. From day one. Then in 2023, when I discovered it during my audit and warned her, she doubled down. He showed me another email thread. My message? Christine, we're operating without corporate authority. Everything we're doing, fee collection, fine imposition, enforcement actions, has no legal basis. We need to stop immediately and correct the incorporation. Her response. David, the community doesn't need to know about administrative filing delays. Our governance structure is functioning effectively. Continue normal operations and don't create unnecessary panic. Administrative filing delays. That's how she framed it, like it was a minor paperwork inconvenience instead of fundamental corporate fraud. David pulled out more documents. But here's what makes it worse. Over the past 3 years, the former compliance officer has systematically targeted families with young children. He spread out violation notices, 7 families, all with infants or toddlers, all hit with massive noise violation fines. Morrison family, baby with colic. Christine issued $200 daily fines for 60 days, $12,000 total. They paid because she threatened a lien on their home. David's voice was tight with controlled anger. Chen family, twin toddlers. Christine claimed their crying violated quiet hours, $8,500 in fines. Threatened foreclosure if they didn't pay. Foreclosure she had no legal power to initiate. Exactly. But they didn't know that. They thought the HOA had legitimate authority. He continued through the list. Rodriguez family, Kim family, Patterson family, Williams family. They have an autistic child who stims loudly. Christine fined them $13,500 for behavioral noise violations. She targeted families with young children and disabilities. Systematically, $85,000 in total fines over 3 years, all imposed under authority the HOA didn't have, all paid by families who thought they had no choice. David pulled out threat letters. Christine would send notices saying, pay fine within 30 days, or HOA will place lien on property and initiate foreclosure proceedings. Pure intimidation using fake legal authority. And you documented all of this. Every violation notice, every threatening letter, every fine payment, every board meeting where Christine justified her targeting of families. He opened the second box. Board meeting minutes from March 2023. Christine's exact words. Young children create ongoing noise disturbances that threaten community property values. Aggressive enforcement of quiet enjoyment standards is necessary to maintain neighborhood desirability. She had a policy of targeting families with kids. Written policy. Documented in board resolutions. Enhanced noise enforcement protocols for residences with children under age 5. Mandatory quiet hours from 7 p.m. to 7 a.m. 12 hours where any child crying could result in $200 daily fines. David's jaw tightened. My daughters are too. If I hadn't been on the board, Christine would have targeted my family too. He pulled out the third box. financial records showing where the illegally collected money went. Most went to enforcement operations. Christine paid herself $60,000 annually as HOA president, paid for security consultants to intimidate residents, hired attorneys to threaten families with liens, all funded by fees collected through fraud. She profited from the fraudulent operation. $480,000 over 8 years in personal compensation, plus expense reimbursements of another $150,000. Christine made over $500,000 running a fake HOA. David closed the laptop. Then she poured boiling water on your daughter and claimed HOA Emergency Enforcement Authority as justification, authority that never existed, that she knew didn't exist, that she'd been operating under fraudulently for 8 years. I looked at the 3 boxes of evidence: the systematic fraud, the targeting of families, the theft by deception, all documented by the treasurer who'd finally found the courage to expose it. David, this evidence, it's going to destroy her, criminally and civilly. 8 years of fraud, theft, intimidation, plus the assault on Mia as the culmination. Good, because I've been complicit long enough. Those families paid $85,000 in illegal fines. 180 households paid $3.1 million in unauthorized fees. Your daughter has permanent facial scars. He pushed the boxes toward me. Use everything. Expose the entire fraud. Make sure the tyrant in heels loses everything. I spread David's evidence across my law office conference table. 3 boxes of documents. 8 years of systematic fraud. Everything needed to dismantle Christine's fake empire completely. Started organizing like I would any complex case. Criminal track, civil track, evidence categories, criminal case foundation. First, the child abuse charge, already filed. Video evidence from Judge Morrison's Zoom recording. Medical documentation of Mia's 2nd and 3rd degree burns. Dr. Rodriguez's testimony about permanent scarring and years of reconstructive surgery ahead. But the incorporation fraud elevated everything. I drafted the expanded criminal complaint for DA Walsh. Count 1, child abuse, existing. Deliberately poured boiling water on 8-month-old caused 2nd and 3rd degree burns. Permanent scarring and disfigurement. Judge Patricia. Morrison witnessed live. Video recorded count 2. Operating fraudulent corporation, Riverside Commons. HOA incorporation rejected August 2016. Never corrected, never refiled, never obtained legal corporate existence, operated for 96 months, collecting fees without authority. Colo. Rev Stat. Parkville 18-5-1902. 5 to 15 years prison. Count. 3. Theft by deception. Collected $30,147,600 in HOA fees without legal standing. Represented organization as legitimate corporation. Residents paid believing HOA had authority. Systematic fraud over 8 years. Count 4. Criminal impersonation. Claimed corporate powers and authority that didn't exist. Used fake authority to threaten, intimidate, and assault. HOA emergency enforcement powers were complete fiction. Count 5. Conspiracy to defraud. Emails prove Christine knew of incorporation failure. 2016 and 2023. Deliberately continued operations despite lack of legal standing. Instructed treasurer to hide fraud from community collected millions, knowing organization lacked authority. Count 6. Organized crime. 8-year pattern of fraudulent fee collection, $630,000 personal profit from fake HOA operations. Systematic targeting and intimidation of residents. Criminal enterprise built on corporate fraud. Each count carried 5 to 15 years. Total exposure, 30-90 years in prison. Civil case strategy. I drafted the class action complaint on behalf of all 180 Riverside Commons households. Cole versus Mercer, et al. Class action for fraud. void corporate acts, return of illegally collected fees. Class representatives: Nathan Cole, assault victim's father; Morrison family, $12,000 illegal fines paid; Chen family, $8,500 illegal fines paid; Rodriguez, Kim, Patterson, Williams, Anderson families, all targeted, all paid illegal fines. Defendants: Christine Mercer, primary, Riverside Commons, HOA, void corporate entity. Board members who enabled fraud claims, fraud and misrepresentation, theft by deception, unjust enrichment, intentional infliction of emotional distress, assault and battery, Mia's injuries. Relief requested: declare Riverside Commons HOA never legally incorporated void. All HOA actions taken without authority, every violation, fine, threat. Return all fees collected illegally, 3.1 ME plus. Return all fines imposed without standing, 150K plus. Void all liens threatened or place damages for families targeted and intimidated. Punitive damages for Christine's knowing fraud. Attorney's fees. Pattern of discrimination. Evidence: David's documentation showed the board chair had specifically targeted families with young children. 7 families over 3 years, all hit with noise violation fines for normal infant-toddler behavior. I organized the evidence. Targeting pattern: 100% of excessive fine cases involved families with children under 5. Average fine for families with babies, $12,143. Average fine for households without young children. $0 board resolution implementing enhanced enforcement for residences with young children. Christine's documented statement: young. Children threaten community property values. This wasn't just fraud. This was discrimination. Systematic harassment of families with babies and toddlers using fake HOA authority as weapon. Expert witnesses: I coordinated testimony. Dr. Amanda Rodriguez, pediatric burn specialist. Mia's injuries, permanent scarring, years of surgery ahead, psychological impact. David Park, CPA, former treasurer. Financial fraud, incorporation failure. Christine's knowledge, systematic fee collection without authority. Corporate law expert. Requirements for HOA incorporation. Consequences of operating without legal standing. Void ab initio principle. Acts of non-existent corporation are void from the beginning. Child development expert. Normal infant crying patterns, impossibility of controlling colic, targeting of families with young children as discrimination. Judge Patricia Morrison, eyewitness to assault, video evidence, Christine's claim of HOA authority while committing crime. Secretary of State, representative, incorporation. Rejection, requirements for correction, no record of successful refiling. Each expert would establish a piece of the case: criminal fraud, civil void acts, discrimination, assault, all built on the fundamental fact: Riverside Commons HOA never legally existed. Financial destruction: Christine's assets, home, $450K equity, retirement accounts, $280K, investments, $150K. Total net worth, $880K. Criminal restitution required, 3.1 NM+6. Return all illegally collected fees. Civil damages, 2 M+6. 7 targeted families, plus Mia's medical costs and suffering. Total liability, 5 in success. The former compliance officer couldn't pay, would lose everything and still owe millions. Bankruptcy wouldn't discharge fraud-based judgments. Prison sentence, 30-90 years based on 6 felony counts. Professional destruction, criminal conviction, disbarment from any corporate roles, permanent record. I looked at the case I'd built. Criminal prosecution plus civil void acts plus class, action remedy. 3 legal tracks converging to destroy Christine completely. The tyrant in heels had operated a fake HOA for 8 years, collected millions, terrorized families with young children, convinced herself her authority was real. Then she'd assaulted my daughter under that fake authority. Now I was going to use legal technicality, the incorporation failure she'd known about and hidden, to void everything she'd done and send her to prison for decades. DA Patricia Walsh filed the expanded criminal charges against Christine Mercer 3 days after I delivered David's evidence. The press conference was held at the district attorney's office with television cameras recording every word. Today we are filing 6 felony counts against Christine Mercer, former president of what she claimed was Riverside Commons Homeowners Association. These charges include child abuse, operating a fraudulent corporation, theft by deception exceeding $3 million, criminal impersonation, conspiracy to defraud, and organized criminal enterprise. The reporters erupted with questions. Ms. Walsh, you're saying the HOA was fake? Not fake, non-existent. Riverside Commons filed articles of incorporation with the Colorado Secretary of State in 2016. Those articles were rejected due to deficiencies. The organization was instructed to correct errors and resubmit. They never did. For 8 years, this entity has been operating without legal corporate existence, collecting fees, imposing fines, and claiming enforcement authority it never had. What does that mean for residents? It means every fee collected was obtained through fraud. Every fine imposed had no legal basis. Every threat of liens or foreclosure was made without authority. And when Ms. Mercer poured boiling water on an 8-month-old baby's face, she claimed HOA emergency enforcement powers that legally did not exist. I watched from the back of the room as the DA displayed the Secretary of State's rejection letter on the screen behind her. Ms. Mercer knew about this incorporation failure. We have emails from 2016 where she was informed of the rejection and chose to begin collecting dues as planned anyway. We have 2023 emails where her own treasurer warned her they were operating without corporate authority, and she instructed him to continue normal operations and don't create unnecessary panic. How much money are we talking about? Over 8 years, $3,340,600 in dues collected illegally, an additional $150,000 in fines imposed without legal standing. Ms. Mercer personally received $630,000 in compensation and expense reimbursements from this fraudulent operation. The same day, I filed the class action lawsuit in Denver District Court. The clerk looked at the complaint, 178 pages documenting 8 years of fraud, and said she'd never seen anything like it. By evening, local news was running the story. Fake HOA president charged with burning baby, collecting millions illegally. My phone started ringing. Riverside Commons residents who'd been paying dues for years, suddenly learning their HOA had never legally existed. Mrs. Morrison called first. Mr. Cole, we paid $12,000 in fines for our babies crying. You're saying the board chair had no authority to fine us? None. Every violation notice Christine issued was legally void. Every fine you paid was collected through fraud. The class action lawsuit seeks to return all illegally collected fees and fines. Can we join the lawsuit? You're already included as class members. Every household that paid fees or fines to Riverside Commons. 7 families called that night, all with young children, all targeted by the former compliance officer's noise enforcement. All had paid thousands believing they had no choice. The Williams family. We paid $1,300 because Christine threatened foreclosure. Our son is autistic. His stimming is loud sometimes. She called it behavioral noise violations. You're saying those violations were fake? Completely. The HOA had no legal standing to enforce any rules. Christine was operating a fraudulent corporation. What about the lien she placed on our house? Void. An entity without legal incorporation can't place liens. We'll be filing to remove all liens Christine threatened or placed. By the end of the week, the story had gone statewide. HOA president ran 8-year fraud, burned baby over noise complaints. Christine's attorney tried damage control, held his own press conference, claiming the incorporation failure was minor administrative oversight that didn't negate good faith operations. I responded through my own statement. Good faith operations don't involve collecting $3 million while knowing your organization lacks legal authority. Good faith operations don't involve targeting families with young children and imposing illegal fines. And good faith operations definitely don't involve pouring boiling water on an infant while claiming corporate powers that don't exist. The Colorado Attorney General opened a separate investigation into HOA fraud statewide, sent investigators to examine Riverside Commons records, subpoenaed all financial documents, board minutes, communications. What they found was devastating for Christine's defense. Board meeting minutes from 2017. President Mercer reported incorporation filing delays, but stated operations could continue normally. Email from 2019. Christine to board members. Incorporation paperwork remains pending, but doesn't affect our enforcement authority. 20-21 board resolution. Enhanced enforcement protocols for residences with young children approved unanimously. 2023 email. David's warning about operating without authority. Christine's response to hide it from residents. Every document showed knowing fraud. Deliberate operation without legal standing. Systematic targeting of families, all while collecting millions. The discovery process revealed more victims, families who'd paid fines years ago, residents who'd modified their homes based on Christine's violation notices, people who'd lived in fear of the board chair's enforcement threats. All of it built on an HOA that had never legally existed. Criminal trial was set for 3 months out. Christine remained in jail, bail denied due to child abuse charges and flight risk given her massive financial liability. The class action moved forward. 180 households as plaintiffs. $3.3 million in illegally collected money to be returned. Punitive damages for knowing fraud. Void all HOA actions retroactively. And through it all, Mia was in the hospital. Second reconstructive surgery completed. Face still bandaged. Years more surgery ahead. Permanent scars from Riverside Commons enforcer claiming authority she'd never had. The legal machinery was in motion. Criminal prosecution, civil class action, state investigation, media exposure, everything converging to destroy Christine completely, because she'd built an empire on corporate fraud. And I'd exposed the legal technicality, the incorporation rejection, that voided every bit of power she'd claimed. The state investigation uncovered what David Park's audit had only begun to reveal. 8 years of Christine's governance, documented in excruciating detail. The Attorney General's investigators found board meeting recordings Christine had kept, apparently believing they showed her conducting legitimate business. Instead, they captured the systematic fraud in her own voice. Recording from September 2016, 1 month after incorporation rejection. The Secretary of State has concerns about our paperwork, but we can't delay operations. Begin collecting dues immediately. We'll address the technical filing issues later. Recording from March 2023, after David's warning. Our treasurer has raised questions about corporate status. This is administrative minutiae that doesn't affect our governance effectiveness. No one outside the board needs to know about state filing complications. Continue all enforcement activities as planned. Recording from June 2024, 3 months before she burned Mia. Families with young children continue to create noise disturbances. I propose escalating enforcement, daily fines, immediate compliance requirements. These residents need to understand that parenthood doesn't exempt them from community standards. Every recording showed Christine knew the HOA lacked legal standing. Every word proved continuing fraud. The investigators also found Christine's personal financial records. What they revealed was damning. Over 8 years, the former compliance officer had paid herself $60,000 annually as HOA president compensation, $5,000 monthly for administrative services, expense reimbursements averaging $18,000 yearly, enforcement consulting fees of $25,000 annually. Total, $784,000 in personal income from an organization she knew had no legal authority to collect fees. But there was more. Christine had used HOA funds to hire attorneys to threaten families, had paid security consultants to intimidate residents, had spent $150,000 on legal enforcement actions, all funded by illegally collected dues. The Attorney General's office filed civil charges seeking full restitution plus penalties. Colorado law allowed treble damages for knowing fraud. $3.1 million in illegal fees, x 3, whoosh, $9.3 million in potential civil liability. That afternoon, I met with the 7 families Christine had systematically targeted. We gathered at my office, parents who'd paid illegal fines believing they had no choice. Mrs. Morrison spoke first. We paid $12,000 because our baby had colic. Christine sent notices saying we'd lose our house if we didn't pay. We were terrified. Every notice was legally void, I explained. The HOA had no authority to fine you, no power to threaten liens. Christine was operating a fraudulent corporation. Mr. Kim added, she made us feel like terrible parents, like our children crying was somehow our fault, like we were bringing down property values by having kids. That was the point, David Park said. He'd come to support the families. The board chair targeted families with young children deliberately. It's all documented in the board minutes. I pulled up the resolution from 2021. Enhanced noise enforcement protocols for residences with children under age 5. Mrs. Williams read it aloud. Mandatory quiet hours, 7 p.m. to 7 a.m. Any child vocalizations during this period subject to $200 daily fines. Her voice shook. My son is autistic. He stims, makes sounds for self-regulation. She fined us $200 every single day for 3 months. $18,000 total. Because she viewed children as property value threats, I said, and she used fake HOA authority to punish families for having kids. The Patterson family had paid $14,000. Their newborn had reflux, constant crying, medical condition, nothing they could control. Christine's response, daily fines until they achieved compliance. How do you achieve compliance with an infant who has reflux? Mrs. Patterson asked. We were giving him medication, seeing specialists, doing everything medically possible, and she was fining us $200 a day like we were choosing to let him cry. Rodriguez family, $15,000 in fines for nighttime crying, normal baby behavior. Christine had called it willful disturbance of community quiet enjoyment. Every family had the same story. Young children, normal infant-toddler behavior, Christine's escalating fines and threats, payment under duress, years of fear and intimidation, all imposed by an organization with zero legal authority to impose anything. The trial starts in 6 weeks, I told them. Criminal case against Christine for child abuse, fraud, theft. You'll all be called as witnesses to establish the pattern. To show this wasn't isolated, it was systematic targeting of families with young children using fake, corporate power. What about getting our money back? Mr. Morrison asked. The class action seeks return of all illegally collected fees and fines, $3.3 million total across 180 households. If we win, and we will, every family gets refunded what they paid to Christine's fraudulent operation. As the families left, Mrs. Williams stopped at the door. Mr. Cole, I'm sorry about your daughter. What Christine did to Mia, she couldn't finish. I know, thank you. But I'm glad it was you. Glad she finally targeted someone who had the legal expertise to expose what she'd been doing. Because the rest of us, we just paid. We didn't know we could fight back. That night, Christine's defense attorney filed a motion claiming the incorporation failure was minor technicality that doesn't negate years of good faith community governance. I filed my response. There is no good faith operation of a fraudulent corporation. Defendant collected $3.1 million, knowing her organization lacked legal authority. Defendant imposed $150,000 in fines, knowing she had no standing to do so. Defendant targeted families with young children systematically. Defendant poured boiling water on an infant while claiming corporate powers that didn't exist. None of this is good faith. All of it is fraud. The trial was 6 weeks away. The evidence was overwhelming. The victims were ready to testify. And the tyrant in heels was about to face a courtroom full of families she'd terrorized using authority that had never been real. The courtroom was packed. 180 Riverside Commons families filled every seat. Media lined the back wall. Judge Marcus Harrison, presiding over what he'd called one of the most unusual fraud and assault cases in his 30 years on the bench. Christine Mercer sat at the defense table in an orange jumpsuit. No longer the confident HOA president who'd poured boiling water on my daughter. Just a woman watching 8 years of fraud exposed in front of everyone she'd terrorized. DA Patricia Walsh began with the Corporate Fraud Foundation. Your Honor, the state calls Rebecca Martinez, Corporate Records Examiner for the Colorado Secretary of State. Ms. Martinez took the stand, brought up the official database on courtroom monitors. Ms. Martinez, please explain what this record shows. This is the filing history for Riverside Commons Homeowners Association. Articles of incorporation were submitted August 14, 2016. They were rejected August 28, 2016, due to deficiencies. The rejection letter specifically states, correct errors and resubmit. Until approved filing is received, this entity has no legal corporate existence. And was a corrected filing ever submitted? No. In 8 years, no successful incorporation filing exists for this organization. Riverside Commons HOA has never legally existed as a corporation. Which means, under Colorado law, an unincorporated entity lacks legal standing to enforce covenants, impose fines, or place liens. Any actions taken are void ab initio, void from the beginning. Christine's attorney tried to object. The community operated in good faith. Good faith doesn't create corporate existence, Judge Harrison said. Continue, Ms. Walsh. Next witness, David Park. Mr. Park, you were treasurer of Riverside Commons. When did you discover the incorporation failure? During a 2023 audit, I found the rejection letter in HOA files. I immediately emailed Christine Mercer, the board chair, warning that we were operating without authority. David's voice was steady now, clear. She responded, continue normal operations and don't create unnecessary panic. Did Ms. Mercer know the HOA lacked legal standing? Yes, I have emails from 2016 where she was informed of the rejection. She chose to begin collecting dues anyway. Then in 2023, When I warned her again, she instructed me to hide it from residents. Why did you comply? She threatened my family. I have twin daughters. Christine came to my house, watched them playing, and talked about how unfortunate it would be if code enforcement investigated our swing set. I understood the threat. D.A. Walsh displayed the financial records. $3,147,600 in dues collected over 8 years. Is that correct? Yes, all collected without corporate authority, plus $150,000 in fines imposed with no legal standing. And where did this money go? Christine paid herself $784 over 8 years. The rest went to enforcement operations, attorneys to threaten families, consultants to intimidate residents, all funded by illegal fee collection. The Morrison family testified next, about their baby with colic, about $12,000 in fines for crying, about Christine's threats of foreclosure. She sent notices saying we'd lose our home if we didn't pay. We believed her. We didn't know the HOA had no authority. 7 families testified, each story the same. Young children, normal infant behavior, Christine's escalating fines, threats that were legally void but felt real. Mrs. Williams broke down describing her autistic son. $200 daily fines because he stims, because he makes sounds for self-regulation. The former compliance officer called it behavioral noise violations and threatened to take our house. Then Judge Patricia Morrison took the stand. Judge Morrison, you were mediating a virtual HOA hearing when the assault occurred. Yes. Mr. Cole appeared via Zoom. Ms. Mercer requested to attend from his location for noise verification. I agreed, thinking she'd observe. Judge Morrison's composure was professional, but anger flickered beneath. Instead, I watched her go to his kitchen, boil water, carry it into the room where his infant daughter was crying, and pour it directly onto the baby's face. The courtroom went silent. What did Ms. Mercer say? Emergency noise abatement. HOA Enforcement Authority permits necessary remediation. She claimed organizational authority while committing child abuse. I immediately called 911 and recorded everything. D.A. Walsh played the Zoom recording. The courtroom watched Christine Mercer pour boiling water on Mia, watched my daughter scream, watched me grab her while the board chair calmly explained her enforcement action. Several jurors were crying. Dr. Amanda Rodriguez testified about Mia's injuries. 2nd and 3rd degree burns, emergency surgery, permanent facial scarring, years of reconstructive procedures ahead. This 8-month-old baby will carry these scars for life because someone poured boiling water on her face over noise complaints. Finally, I took the stand. Mr. Cole, why did you investigate the HOA's corporate status? Because Christine kept invoking HOA authority and charter powers to justify assaulting my daughter. Those are legal terms. They require legal standing. As a family law attorney who handles HOA cases, I knew to verify that authority existed. I looked directly at Christine. When I checked the Secretary of State database and found the incorporation rejection, I realized everything she'd claimed, every fine she'd imposed on families, every threat she'd made, every piece of authority she'd used to terrorize residents and burn my daughter, was built on fraud. Your daughter? Mia lost her mother 5 months before Christine assaulted her. My wife Jessica died from postpartum complications. Mia is all I have left. And the tyrant in heels permanently scarred her while claiming corporate powers that never existed. The jury deliberated for 47 minutes, guilty on all 6 counts. Christine Mercer sat motionless as Judge Harrison read the verdicts. The woman who'd operated a fraudulent HOA for 8 years collected millions, terrorized families, and burned a baby's face, was finally facing consequences. Sentencing in 30 days. Defendant remanded to custody. The courtroom erupted in applause as they led her away. Judge Harrison sentenced Christine Mercer 6 weeks after the jury's verdict. I sat in the courtroom holding Mia, now 11 months old, face still healing from her 3rd reconstructive surgery. Ms. Mercer, you operated a fraudulent corporation for 8 years, collected over $3 million from families who believed they were paying legitimate HOA fees, systematically targeted families with young children, imposing illegal fines totaling $150,000. Then you poured boiling water on an 8-month-old infant's face while claiming corporate authority you knew didn't exist. Judge Harrison looked at the former compliance officer with disgust. On count 1, child abuse, 15 years Colorado State Prison. Count 2, operating fraudulent corporation, 10 years consecutive. Count 3, theft by deception, 12 years consecutive. Count 4, criminal impersonation, 8 years consecutive. Count 5, conspiracy to defraud, 10 years consecutive. Count 6, organized crime, 8 years consecutive. 63 years total. Christine would be 110 years old before becoming eligible for parole. Additionally, defendant is ordered to pay full restitution, $3,297,600, to be returned to Riverside Commons residents. Defendant's assets will be liquidated to begin payment. The board chair's home, retirement accounts, investments, everything seized. She'd still owe millions she could never pay. The civil class action settled 2 months later. Every household that had paid fees or fines to Riverside Commons received full refunds. The Morrison family got their $12,000 back. The Williams family recovered $1,300. All 7 targeted families compensated for years of illegal harassment. Judge Harrison's ruling was definitive. Riverside Commons Homeowners Association never achieved legal corporate existence. All actions taken by this entity from 2016 to 2024 are void ab initio, void from the beginning. Every violation notice, every fine, every threat of lien, legally meaningless. Residents were paying fees to a DUE organization that had no authority to collect them. 180 families freed from 8 years of fraudulent governance. The community held a vote about whether to properly incorporate a new HOA or operate without one. They chose proper incorporation, this time with legal verification, oversight, and strict limits on enforcement. The new articles of incorporation included explicit protections. No fines for noise from children under age 12. No enforcement actions involving physical contact. No emergency powers permitting immediate compliance measures. All actions subject to legal standing verification. David Park became the new treasurer. His first act was displaying the incorporation certificate in the community center. Approved. Legal corporate existence established. Mia turned 1 year old 3 months after Christine's sentencing. Dr. Rodriguez said the scarring was permanent, visible across her left cheek and forehead. 3 more surgeries planned over the next 5 years. My daughter would grow up answering questions about what happened to her face. But she was healing, laughing, starting to walk, living the life Jessica had dreamed of when she'd knitted that baby blanket. I'd preserved the blanket, blood-stained, evidence of Christine's assault. Kept it as reminder that fake authority backed by nothing but intimidation can be destroyed by legal technicality. That corporate fraud, no matter how long it operates, collapses when someone verifies the foundation. Christine Mercer had convinced herself that collecting fees and terrorizing families for 8 years made her authority real, had believed that board votes and enforcement actions created legitimacy. She'd been wrong. Colorado law required proper incorporation. Without it, every fine was theft, every threat was fraud, every claim of power was fiction. And when she'd poured boiling water on my daughter while invoking that fake authority, she'd committed child abuse under claim of corporate powers that had never existed. The legal technicality, the incorporation rejection from 2016, had been the key. One rejected filing, never corrected, never refiled. That single administrative failure voided 8 years of operations and destroyed the tyrant in heels completely. 63 years in prison, $3.3 million in restitution she couldn't pay, professional destruction, permanent criminal record, civil judgments that would follow her forever. All because she'd operated a fraudulent corporation and convinced herself the fraud was legitimate. Mia was playing with blocks on my office floor, making sounds Jessica would have loved to hear. Scarred, but alive. Safe from the former compliance officer who'd used fake HOA authority to justify assault. The community was healing too. No more threatening enforcement. No more targeting families with young children. No more fake authority terrorizing residents who just wanted to raise their kids. If you want more stories of homeowners standing up to HOA tyranny, hit subscribe right now, share your story in the comments, and let me know where you're watching from. Because legal technicalities matter. Corporate incorporation requirements exist for reasons. And when someone builds power on fraud, exposing that fraud destroys everything they've created. Christine learned that lesson in a 63-year prison sentence.